Mr. Smith?
Well, for jury trials, I would. I mean, I like to try jury trials in person, but non-jury trial stuff, the hearings, it saves the clients so much money. We don't have to get in our cars and go to the courthouse and
Okay, we're live. We're live now. So let's go ahead and start the proceeding. I'll call the case of Donald E. Budd Jr. versus H. Reed Walker Esquire and Reed Walker PA appellants. The parties would state their appearance, please.
Good morning, Your Honors. This is David Larson. I represent the appellants in this case, Reed Walker and his law firm. With me here this morning, although she's off camera, is Kate McKinney, who's my local counsel.
Okay, thank you.
if the court please, Pete Smith and McDowell Rice, Smith and Buchanan, representing the appellee Don Budd, who is also present in person with me off camera.
Okay. And Mr. Larson, did you wish to reserve any time?
I would like to reserve 5 minutes, Your Honor, please.
Okay. And as I've, since you all have just been, we've just called this case, I'd like you to know that I'm Chief Judge Karen Arnoldberger. I'll be the presiding judge today, and joining me is Judge Tony Powell and Judge Amy Fellows Klein. We have read your briefs. In many cases, we've reviewed a lot of the record in your case, so you don't need to spend a lot of time on the facts since you only have 15 minutes to argue. And with that, I will allow you to go ahead and start, Mr. Larson.
Thank you very much, Your Honor, and may it please this court, it's certainly a privilege for me to appear before this court this morning, and I appreciate that opportunity on behalf of my clients. The facts, in our view, that give rise to this appeal that are material to this court's determination are not in any serious dispute at all. As a preliminary observation, as you no doubt saw in our briefs, these facts, when viewed in the appropriate lens by this court, that being that malicious prosecution lawsuits against lawyers are disfavored in the law. And for that reason, each element of the tort is to be strictly construed. When viewed in that light, we believe the only conclusion that can and should be reached by this court is that the judgment entered against my clients must be reversed outright. Now, we have presented to the court several grounds for reversal. They are interrelated, but I must emphasize that they each stand on their own and represent separate and distinct bases for reversal. So if the court agrees with just one of those points, which we believe the evidence is compelling to do so, then the appropriate relief that should be entered is outright reversal. And that's what we are asking this court to do. Now, Kansas law protects the property rights of individuals who separate from a relationship in which there is no ceremonial marriage. These rights have been observed and implemented by the Supreme Court of Kansas, and they did so in the case of Eaton versus Johnston, which is a very important decision, certainly cited by both parties, but also referenced in the underlying proceedings by both parties. In that case, the Supreme Court recognized a two-pronged process, a framework for protecting the rights of individuals who are leaving a long-standing relationship but have de facto prima facie property rights that were accrued during the relationship. It's an either-or situation as laid down by the Supreme Court in that case. If the elements of a common law marriage are established, then the trial court will proceed to determine property rights in accordance with the marital statutes. In the alternative, if no common law marriage is found, then the court has the inherent equitable rights to assess by an equitable basis, the parties' respective claims to the property that was either jointly acquired or acquired for the purpose of contributing to the joint relationship. So with that in mind, our first ground for reversal.
Mr. Larson, may I
Yes, Your Honor.
comment about that point? Did Ms. Tanky in her divorce petition in the Johnson County District Court, did she plead in the alternative where, did she plead a common law marriage, sought a divorce, and then of course equitable division of property? Did she plead in the alternative, in essence plead, well, if there is no divorce, did she seek an equitable division of their joint, whatever joint property?
The answer to that is yes, Your Honor. He did ask for alternative relief if there's no finding of a common law marriage.
The other thing that I thought was interesting in this case was that Mr. Budd filed I guess a declaratory judgment action. I'm not entirely sure what his plea was, but he basically sought a declaration from the Wyandotte District Court of a determination of whether the parties were common law married. And as I understand it, that was filed after the Johnson County divorce case was already pending. Is that correct?
Absolutely correct, Your Honor. The Johnson County action was filed. Mr. Budd then filed his declaratory judgment action in Wyandotte County, asking for determination on whether there was or was not a common law marriage. Mr. Budd then went to Johnson County and asked the Johnson County judge to stay any further proceedings in that case pending the outcome of the declaratory judgment action. And that was done.
Did Ms. Tanky ever seek dismissal of the Wyandotte County case on the grounds there was already a pending case in Johnson County that was going to decide this question of whether the parties were common law married? No, did not do that. Mr. Budd apparently beat Ms. Tanky to the punch and went to the Johnson County District Court to say, hey, we want you to stay, so the Wyandotte County District Court can resolve this question. I think it's what happened instead.
You're breaking up a little bit, Your Honor, but as I understand your question, arguably such an attempt could have been made, but the decision was made by the Johnson County judge. I'm going to sit on this case, let it proceed, and get disposed of in Wyandotte County. One important matter of fact to note here too is when the initial declaratory judgment action was filed by Mr. Budd, there was no request for anything other than the determination of whether or not a common law marriage occurred. However, within just a matter of a week or two before the hearing in Wyandotte County, Mr. Budd made a specific request to the Wyandotte County judge pursuant to the Eaton, and specifically cited Eaton versus Johnson, and said, we want this court to make an equitable determination and allocation of property rights between these parties.
Was that request made after basically Ms. Tanky and her lawyer, I guess maybe principally Mr. Walker, was saying, well, we're not going to dismiss the Johnson County action because we're seeking an equitable division of property in the event that there's a finding that the parties are not common law married, and that wasn't originally sought by Mr. Budd in the Wyandotte County case?
No, that decision to make that request was solely attributable to Mr. Budd and his counsel. And that of course folds into the argument that I'm going to present.
Go ahead, Mr. Larson. I'm sorry to stop you in your tracks.
Thank you, Your Honor. Well, our first point on appeal is that probable cause, one of the elements of this tort is the plaintiff must prove the absence of probable cause to bring the action that was brought. It's our belief under the clear record here that there's probable cause for any lawyer to determine that at the very minimum, Lisa Tanking had property rights that were accrued during their almost 20-year relationship with one another. They were joint tenants on a deed to a property that where their residence that they lived together for over 15 years was located in Wyandotte County. So to us, that is a prima facie case of probable cause to bring an action to determine the existence of and the extent of Lisa Tanking's interest in that home.
Is that a legal question or is that a fact question, Mr. Larson?
Well, I think when the facts are not in dispute, as they aren't here, it's a legal question for this court to determine whether the probable cause existed as a matter of law, which we believe that you can and should make that finding. Yes, sir. To further confirm the existence of probable cause, the actions that came from the Wyandotte County action only further established the existence of probable cause, because the Wyandotte County Court, although he determined that there was no common law marriage, he determined that Lisa Tanking did in fact have an equitable interest in this property. And he identified it as 20% of the net value without knowing what the net value was when the court entered its order. She was accorded rights to this property, all as prescribed by Eaton versus Johnson. So one can only conclude that probable cause existed to make a request for an equitable determination of proceeds, just like Mr. Budd did himself. He's complaining here that we asked for that in Johnson County, and yet they asked for the same relief in Wyandotte County. We don't see how that could possibly square with a claim for malicious prosecution for the Johnson County action.
Come to the end of your first 15 minutes, Mr. Larson. Do you
It
want
goes
to
fast, doesn't it, Your Honor?
It does. You want to sum up real quick, and I'll go, and then you'll still have your 5 minutes for rebuttal.
Yeah, sure. I will just go to the next couple of points real quickly. Is that to be entitled to malicious prosecution, you must show that you prevailed on all claims that were asserted against you. As just discussed, Mr. Budd did not prevail on all claims. Even though it was in Wyandotte County, he did not prevail on all claims. In fact, he argued to this Court of Appeals in that case that he was aggrieved by that ruling. So clearly not a favorable outcome for him. But that dovetails to the next argument, is that get it in front of me.
Okay, well, we'll do that on rebuttal, okay?
Okay, I'll come back to it, Your Honor. Thank you.
Okay. Mr. Smith?
Thank you, Your Honor. Reed Walker filed a divorce case against Donald Budd that was an absolute fraud. His client had jointly owned property in Wyandotte County with Don Budd. Her remedy, and what she went to Reed Walker for, was to get her share of that property. Partition was her remedy. Partition is required to be brought in the county in which the property is located. Lisa Tanking told Reed Walker, "I do not want to be in the Wyandotte County District Court. I don't like the judges there. I don't think I'll get a fair treatment. I want to get out of Wyandotte County. Get me out of Wyandotte County." Reed Walker then developed a bizarre plan to have Tanking move to Johnson County and file a petition for divorce alleging a common law marriage. And then, which is a case that he planned on losing. And when he lost, he would have the court divide up the Wyandotte County property under this Eaton versus Johnston. Think of it like this. Let's say two brothers had inherited a piece of property from their father, and they were joint tenants of that piece of property, and they go to Mr. Walker, and the properties in Wyandotte County. And one of the brothers that's going to be his client says, I don't want to go to Wyandotte County. I don't like it over there. I've heard that you don't get good justice there. I want to go in Johnson County. And he says, okay, move over to Johnson County. We'll file a divorce case against your brother. And his client said, well, we're not married. He said, that's okay. We'll file this case. And when we lose it, under this case, Eaton versus Johnston, the Johnson County court can divide the property and you can get it out of Wyandotte County. And that's exactly what he did here. And let me look first and kind of anticipating what behind Judge Powell's question about were there alternative requests for relief there. There were not two claims. Walker wants to say in this case there were two claims, one for a divorce and a separate one for equitable division of the property. There are no claims like that. There's only one claim, one petition. It's a petition for divorce. It was filed twice. You can look at it. It is a divorce case, pure and simple. Eaton versus Johnston did not give a separate cause of action. Eaton versus Johnson was a case where somebody righteously and in good faith and with probable cause files a divorce case.
Mr. Smith, is that petition that Ms. Tanky filed in the Johnson County District Court, is that in the record?
Yes, it is. It's in the record. It's a divorce case. He does say in that, if there's no divorce, if there's no marriage, if we lose the divorce case, we want you to divide the property. He did say that in the pleading. It was a one count petition for divorce. That's all it was, petition for divorce. So when you look at Eaton versus Johnson says, when there's a divorce case, a real divorce case, filed in good faith with probable cause, and the court decides, well, what happened there was the court decided there was no marriage. So the court says, hey, there's no marriage. I can only divide property under the divorce statute. Since there's really no marriage and no divorce to be granted, I can't divide the property. And the Supreme Court said, no. While they're here, you might as well go ahead and divide the property. You can divide this jointly owned property while they're there as a matter of adjunct jurisdiction. It's not a separate claim. The brother could not go to Johnson County and sue his own brother for divorce to come in under this theory. It shows what happens when the case is lost, not an alternate theory. Now, I want to go to why I filed a Wyandotte County petition for declaratory judgment case. When Walker filed the divorce case in Johnson County, he knew exactly what he was doing. He had all kinds of leverage over Don Budd. He could get a temporary restraining order freezing his assets. He could get an order for attorney's fees. He could get order for maintenance. He could ask for division of all the property. This was supposed to be an alleged divorce case of 16 or 17 years. In Johnson County, we had to list and categorize and value every single asset that Don Budd had whenever he acquired it during that 17-year period, not just the one single piece of property that was relevant would have been relevant in the partition case. So faced with that, and Walker admitted that the divorce case would give him a lot of leverage over Don Budd because he'd be able to ask for all those things, and Don Budd would have to defend against it. So I filed to avoid a full-blown divorce case. I filed a petition for declaratory judgment in Wyandotte County to determine there was no marriage. Judge Duncan heard that, and in Judge Duncan's words, I think we ought to see if there's a marriage first before we spend a lot of money defending a full-blown divorce case. And that's what I wanted to do. I didn't want to go defend a full-blown divorce case in Johnson County with assets and liabilities, income and expense. He's asking for maintenance. I simply wanted to win the Johnson County case by winning that single issue in Wyandotte County. Now, when we go to this probable cause, I find that I'm just, if I didn't have so much hair, I'd try to pull it out at this allegation that there is a probable cause. I've heard that for the last 6 years. If there's ever a case where there's no probable cause, when you look at what he knew, the very first day he looks at an intake form before he meets face-to-face Ms. Tanky. There's a place on a date and time of marriage, date and place of marriage. Date of marriage, 0 in her handwriting. Place of marriage, 0. And he asks her, do you have an agreement that you're married? No, we don't. Are you married? No, we are not. Have you ever held yourself out in the community as husband and wife? No, we never did. Now, if he says, well, I'm a lawyer, been doing divorce things for a long time, and I think maybe I can prove a marriage. It is impossible to prove a marriage when your client admits that there is no agreement to be married and they didn't hold each other out. In fact, when I took her deposition, I said to her, did you ever talk with Don about marriage? Yes, we did. We talked about it. What did you say? Well, we discussed the fact that we had each been married separately before that, and marriage wasn't in the cards for us. They talked about and deliberately decided not to be married. So then, what do I hear? I'm still hearing about this ring and the anniversary party. First of all, Don Budd is a pawnbroker. He got a nice ring at a cheap price from a pawn, and he gave it to Lisa Budd 10 years after the alleged common law marriage. It's not a wedding ring. And the anniversary party, the only thing wrong with it is it wasn't an anniversary party. If you look at that invitation I've looked at for 6 years, it never says anniversary. It never says married. It never suggests these parties are husband and wife, period. And then if you look at the math, it's a 20-year party. In 2016, the common law marriage is supposed to be in 1999, 17 years earlier. Why are they having a 20-year anniversary party 17 years after this common law marriage? It is a joke. It didn't exist. There was never any common law marriage. What he wanted to do was to trick the system. Now and the other documentation, 16 years of single tax returns. She gets her passport application as a single person. What's interesting is that the deed, she had a half interest in this property, and the deed to the property that gave her the half interest that was done about 10 years into this alleged marriage. Look at that deed. It says from Don Budd, a single person, to Don Budd, a single person, and Lisa Tanking, a single person.
Mr. Smith, before your time is up, let me ask you to hit on, please, this issue of whether or not Walker failed to prevail on his claim. Let me hear your best argument as to why Walker failed to prevail when there was a finding that she was allowed a 20% interest in the property.
Well, of course she was entitled to interest in the property. She was a joint tenancy. She was a 50% joint tenancy owner on a deed. But the reason that we prevail in this case is, first of all, my malicious prosecution case relates to the Johnson County divorce proceeding, period.
And was it dismissed on the merits?
It was dismissed on the merits. It was absolutely dismissed on the merits in the Johnson County case, and I won that case.
Tell me how it was dismissed on the merits.
It was dismissed on the merits because Mr. Walker goes to court, would not agree to the dismissal, challenged the dismissal, and Judge Hauber in Johnson County says, in this case, first of all, before we go to get it dismissed, what happened in Johnson County earlier, after I filed the Wyandotte County case, Walker tried to stay that. We have no first to file rule in Kansas. He tried to stay that, filed a motion to stay. That's where Judge Duncan said, I think we ought to find out whether there's a marriage before we spend all this money litigating a full-blown divorce. Then about a month later, we go over to Johnson County on a status conference. I show up, Reed Walker shows up. Judge says, what's this going on? A status conference. Walker wants to set some dates. I say, Judge, I've already got a trial date on the issue of whether there's a marriage before you set all these dates. So Judge Hauber says, okay, before we do anything, and I didn't file any motion to stay or anything. Judge Hauber says, okay, what we'll do is, who's handling it? I said, Judge Lamson. He said, okay, I will defer to Judge Lamson. I'll wait and see what Judge Lamson does on the marriage, whether there's a marriage, and then we'll take it up over here. Now, I came back to the Johnson County divorce after I won in Wyandotte County, and Judge Hauber says, the issue in this case is whether
Did you win in Wyandotte County, Mr. Smith?
I absolutely did win in Wyandotte County. Number one, I determined there was no marriage. And number two, they determined that she was really not entitled to anything. I want to address that. There are two claims. Is number one, they won this piano. We never claimed the piano. And so when the judge says she gets her piano back, that's fine because we never claimed it. I kept writing Reed Walker tell her where we can get the piano. We want to give it to
I
her.
don't see any issue about the piano. I'm just concerned
So-
about the 20% interest
Okay,
in the
so,
property.
so the 20% of it, the evidence was from the very outset that Don Budd spent $1.2 million on the property. He testified that if none of this divorce would ever happen, he believes that she would have signed the deed over to him because nobody would, the property would never have been worth $1.2 million in a partition case. In a partition case, he would get credit for what he spent on the property, and then she would get anything left over. There was nothing left over in the final analysis. We all knew in advance, our evidence was there would be nothing left over because there's no way it would be worth over $1 million, and he had spent $1 million on it. So in Wyandotte County, at the final analysis, he ordered her to give a deed to us to the property, and she got no money from it. Now, on the Court of Appeals, why did he appeal? He appealed that finding of Judge Lamson to the Court of Appeals. And in his brief in that, he says, he didn't give us anything. We lost, we got nothing. Now he's saying, well, we really got, all we wanted was a fair shot at it. 20% of nothing is nothing. The evidence was always there would be nothing. And what Judge Lamson did is he emulated a partition case, which he could do because the property was in Wyandotte County. He used the partition procedure. He appointed 3 people from his partition panel to appraise it, gave us the money that we would be entitled to off the top in a partition case, and then divided it after that. But the case that I'm here on is a case in Johnson County. We won the Johnson County case without a doubt. And we won it based upon what the finding was in Johnson County. There was not a procedural determination that, well, as a matter of hocus pocus, procedural whatever, we're going to technically get this case dismissed. We won the case. There was never any divorce case, and we won that. And we won every issue at every stage in every court. We went to the Court of Appeals. In the Supreme Court, she ended up dismissing her case after that. But he won the case. And if you look at Judge Haber's findings that were on the record, he said a marriage was alleged in this action. That was the issue in this action. The Wyandotte County Court found there was no marriage. I don't care what it's called, ceremonial or common law, about whatever. The bottom line is the court found that. According, I'm signing the journal entries submitted by us. So we did win that. I want to make another comment on these special rules and section 674 comment D to the restatement, announcing Nelson versus Miller. I mean, there are rules that help a lawyer. If a lawyer doesn't think there's probable cause, he can go forward anyway. And comment D says that even if the chances are slight, he can press the case if his client insists after he's explained to the client the nature of the chances. And it goes on to say if he knows the chances of success are comparatively slight, he can proceed if his client so insists after he's explained to the client the nature of the chances. She didn't even know the case was still pending in Johnson County. Before the Wyandotte County case, she sends Walker a text saying, get rid of this. We don't have to argue whether there's any marriage anymore. It's just like I owned the property with a neighbor who wanted to divide it up. What did he do then? Was his client insisting of go forward? No, his client wanted to dismiss. What did he do? He ignored her. We went to a trial on a divorce case, went through post-trial stuff, went through an appeal to this Court of Appeals where he was still alleging a marriage, and then went to the Supreme Court after that. So it is without doubt that he doesn't qualify under that. Comment D goes on to say that if he's liable, even if he has probable cause, if he proceeds for an improper purpose, there's a 0 chance that he had probable cause, 0 chance. On improper purpose, it says such as putting a pressure on the other side, making him pay something. He put the pressure on Bud. Bud testified to that, and the jury believed him. I mean, that's a matter of fact. Did Bud believe that he was pressured by this Johnson County courts where they're asking for a temporary restraining order, maintenance, proper division of all the property occurring during the marriage? He said he felt like he'd been extorted. But the real thing that he did in this case was he tried to trick the system. I mean, he tries to file a divorce case in Johnson County between 2 admittedly single parties, just like a brother and a brother, in order to lose the case so he can have the Johnson County divorce case divide up Wyandotte County property that the statutes in Kansas say ought to happen in Wyandotte County. It was a
I
case.
think you're out of time,
Okay.
Mr. Smith. Do
Okay.
you want to take 30 seconds or so to wrap up, or?
I've said it all. I won't remember what I said, so I've said it all.
Thank you, Mr. Smith. Okay, your rebuttal time, Mr. Larson.
Thank you, Your Honor. I will answer your question directly. There was no finding of any kind on merits or touching upon the merits in Johnson County. None whatsoever. The entire dispute was adjudicated in Wyandotte County. Judge Hauber deferred on comedy grounds only, on procedural grounds. Even Mr. Smith made reference to res judicata. You know, it's from the case law we have focused the court on, to which there was no response from the appellee to any of the case law that we put forward. A termination on the basis of a procedural dismissal is not a favorable termination for purposes of malicious prosecution, particularly under the strict requirements to meet the elements of this tort. The same is true with the fact that what I was going to add was this dispute between those two parties was ultimately resolved by a settlement that we weren't even allowed to get into evidence, but they settled their case with Ms. Tanking, which required her to dismiss the appeal that was pending before the Supreme Court of Kansas. The authorities we pointed out to the court in our brief clearly state resolution of a claim, termination of a claim by way of settlement is not a favorable outcome for purposes of malicious prosecution. Another comment I'll make is Mr. Smith talked about partition being the appropriate way to do this. He didn't even ask for a petition. So there are different procedural vehicles that parties can utilize to obtain relief. Mr. Walker utilized an established procedure to, as laid down by the Supreme Court, an either or proposition. If the common law marriage does not exist, which both parties asked judges to determine, not just us, then the court can and should consider the equitable. Mr. Smith has injected a lot of things into this argument that are not a matter of the record of this case. It's his own testimony, I would submit. But even so, the fact that they did not prevail in Wyandotte County, there was no prevailing at all in Johnson, as I indicated. But the finding of a 20% interest completely vitiates the cause of action for malicious prosecution, because Ms. Tanking did prevail on that claim because her interest was identified and recognized and judicially found to exist by the court. That was Mr. Walker's objective from the get-go, to try and get her what she was entitled to out of that property. Unfortunately for her, the way the numbers stacked up did not arrive in an amount that came into her pocket. But as Mr. Smith argued to the appellate court on Mr. Budd's behalf, that finding actually was harmful to Mr. Budd, because in his argument, Ms. Tanking should have been required to pay him back for the deficiency between the fair market value of the property and Mr. Budd's investment in it. So on no basis can there be a claim here or a finding that somehow that 20% interest that was judicially found cannot be somehow just disregarded and ignored for malicious prosecution purposes. And the only other thing I'd like to wrap up with, Your Honors, and thanks for your indulgence, is when you do go to the question of legal malice, the court has to look at the evidence to support legal malice. And that means what was the lawyer doing other than trying to protect the legitimate interests of his client. Well, her legitimate interests were to try and protect her property rights. Everything he did, to which he testified, and there's no evidence to the contrary in the record, everything that he did was to accomplish that goal. So to say that there was legal malice here when viewed in strict standard and strict scrutiny required by this court is also another grounds for reversal. The court knows, I think from reading our brief, that we've made an alternative request for a new trial. We don't think that is something that should really do nothing other than become moot, frankly. But if the court does get to that point and denies the relief we're seeking as to outright reversal, then we do ask the court to consider granting a new trial on the basis that this settlement agreement was concealed from the jury. There was evidence that was put in about the fact that this appeal was dragged out, and Mr. Budd's been a defendant for 900 some days or whatever. That wasn't our case. We were in Johnson County where that case was sitting still, pending the outcome of Wyandotte County on a case that they initiated. But even so, they resolved that appeal by settlement. All claims against Tanking were dismissed, and the jury was denied that fact. I don't know how you can do that in a case of malicious prosecution. So unless there's any other questions, I will conclude on that note. Thank you, Your Honor.
I don't hear any other questions, so thank you very much. We will conclude this matter. We'll take it under advisement and get you an opinion out as soon as possible. Thank you very much for your argument